Is he here?
Mr. Ernest Diaz? Yes, he's
Yes,
here,
he's
Your
here.
Honor.
Okay,
Just a
so-
second.
This happened maybe in an ALS.
Okay.
Good morning, Mr. Diaz.
In Spanish, please.
Buenos días,
Sir,
señor Díaz.
You were arrested for aggravated battery. I will appoint the public defender's office for you.
Señor, usted fue arrestado por agresión con agravante. Le voy a nombrar la oficina de los abogados de oficio para que lo represente.
There is probable cause for the charge.
¿Existe motivo fundado para esta acusación?
So you are ordered to stay away from Nelson Narir, the alleged victim.
A usted se le ordena mantenerse alejado de Nelson Narriel, la supuesta víctima.
No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con la víctima ni directa ni indirectamente, ni en persona, ni por escrito, ni por teléfono, ni por medio de terceras personas.
And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times.
Y tiene que mantenerse alejado de la víctima al menos 500 pies de su lugar de estudio, vivienda o trabajo en todo momento.
You understand? And also you can only return to the victim's residence one time only within 48 hours of your release from jail.
Además, únicamente puede regresar a la casa de la víctima una única vez dentro de las siguientes 48 horas de que salga en libertad.
To retrieve your personal, you must go with a police officer so that you can retrieve your personal belongings.
Y tiene que ir acompañado de un oficial de policía para que usted pueda retirar sus artículos personales.
And if you go without the police or if you stay there, you will be arrested.
Si usted va sin la policía o si se queda ahí, va a ser arrestado.
Also, you have an immigration hold.
También tiene una retención de migración.
There's probable cause for aggravated battery. State, what do you want? 7,500? He did had a 30-year prison sentence for murder, so I think that would be probably a wise move, even though he's 81 years old, to set the standard bond of $7,500.
Ok, señor, tiene una fianza de $7,500. Aparentemente sus antecedentes, usted tiene una condena de 30 años por intento de homicidio. Así es que a pesar de que tiene 81 años, esta es la fianza adecuada.
$7,500 bond. Good day, sir.
Tiene una fianza de $7,500.
Your Honor, the next person on the calendar session, he refused court.
Okay, let's the Derek session. Give me 1 second.
No problem.
Give me 1 second. Never did one of these. Do probation ones. All right, next, I'm sorry, the Derek session refused, you said?
Yes,
You want to waive his presence? It's an.
Yes, we can wait.
Oh, he's right with Mr. Campbell. That's junior, not senior. So there's probable cause for battery by a detainee on another detainee. Bond is $2,500. Next up is George Scott.
He's in JMH, Your Honor.
He what?
Ward D.
Ward D.
Thank you. Does anybody review for PC or did I? No,
Yeah, I think last week.
Yeah, he's been in custody since the 22nd of
The
December.
public defender's office has been appointed?
If not, we should, it just should be simple possession. If he was here, he would qualify.
Yeah,
for
they
that.
PC. All right,
Your Honor, Ward D's on the Zoom.
they are?
I think so.
Is the hospital here? Can you let us know who you are? There we are. See ya. Miss Eth, did your Zoom's change? Mine's all dark now.
No.
I just promoted the hospital. I don't know if they're there. Hello,
Hello,
what is your name, sir?
George Scott.
Hi, Mr. Scott. You got arrested for possession of cocaine within 1,000 feet of a church or convenience store. There's probable cause for possession of cocaine.
Yes,
So
ma'am.
public defender's office is appointed for you. He's been, can I just give, do we have a date for him yet? We can just borrow arms to get out of jail.
Let's see, hold on.
It's F25-27314. January 21st? January, next month. You have to be in court on January 21st at 9 a.m. That's in 2026. Courtroom, let's judge. Courtroom 48. Which Hirsch is that? Richard? Richard Hirsch. So can somebody at corrections write down January 21st at 9 a.m. for him?
Yes.
Okay, thank you. At 9 a.m., it's courtroom 48. You got to come to court. I'm going to release you on your own recognizance so that way you can just get your medical care and just keep all future court dates. There's probable cause for third-degree felony possession of cocaine. All right?
Thank you very much, Your Honor.
Feel better.
Corrections. Could you write down the public defender's number for him to, I can give it to
Yes.
you. Okay, it's 305.
I have it.
Oh, you have it? Okay, perfect.
All right, have a nice
Thank you.
day. Thank you, corrections.
Thank you
Hey,
very much.
Ward D, are you?
Michael, thank you for gifting membership. Very much appreciate that.
All right.
Hospital,
Tomorrow?
Yep.
you can't do it today?
You can't do it today. He's in
I'll see you
another,
tomorrow.
another section.
No worries, thank you. Wayne Lane is next.
Yeah, Ward D, Your Honor.
Is he at the hospital?
Yes, he's Ward D.
Let me review for probable cause.
Count one should be a third-degree felony.
Okay. So count one, there's 1 minute.
40, 47.
Did I miss it?
No, I'm just reading
Okay.
his review of PC where it says car was stolen.
What is it? It's a Gucci?
I got it.
Well, not,
So count one probable cause for grand theft to third degree
I don't know
felony.
why I said, sorry.
Corrections, your volume's on. Your microphone.
Thank you.
All right, count two, there's probable cause as well. What was it, Word D? Reset tomorrow. Reset this afternoon, excuse me. Next case, Anthony Brown, page 13.
Your Honor, Mr. Brown, he
Reset. Where's
No,
the
Mr. Brown is here.
Oh,
This is the
that's
added
right.
charge.
Added charge. Hi. Good morning, Mr. Brown. You were arrested for a case from September 11th, of 2023. The charge is aggravated battery on a pregnant victim. I will appoint the public defender's office for you. So, sir, are you currently still together with the victim, Yesenia Valadares? Do you, it's domestic. Is he still together with her or no? The former girlfriend?
Are you with?
Me?
No.
No. Thank you. Yes. So there's probable cause for the charge. He slapped the victim on her face and also struck her on her legs. Pulled her out of the vehicle. Fled the scene. All right. You are ordered to stay away from the alleged victim, Yesenia Luisa Valadares. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times. Do not engage in any criminal activity, do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir? I can't hear you.
You understand?
Yes, ma'am.
Do you see your children that you have with her?
Yes.
Third-party contact is permitted for exchange of the children for time sharing, okay? You see the children?
Yes, I can see him all the time.
All right, so you can go through a third party. That's why I asked you if you're still with her. You do.
No, I'm not with him. I had no dinner with her in
Say it again?
I had no dinner with her in 2 years.
I don't know what you said.
But he's been in custody, I think, Judge, for a while.
Oh, okay.
I have no dinner.
Got it.
2 years ago, that was it.
I'm sorry, it's hard to hear. The acoustics are bad.
Because I'm trying to figure out.
It's a delayed arrest. It's from 2022.
2 years
right?
old.
Yeah, because
2023.
and I'm nowhere around.
State, what do you want for a bond? $2,500
That's fine.
bond. Okay. All right, next case is Nelson Perez.
Your Honor, these are added charges.
Thank you.
While we wait for the next contestant to come up, just a note for channel members, the pre-show will be making a triumphant return in January. I haven't decided yet if it's going to start on the 5th or the 12th, but it will start back up. You need to be a channel member to access the pre-show, though, so if you are out there and you are not a channel member, please consider becoming one. A whopping $2.99 a month. Not a lot. It goes a long way to support the channel, and you get extra content, plus early access to everything we post.
Okay, so where is Nelson Perez? Coming in the long way?
No, Your Honor, Nelson Perez refused court. These are added charges.
Thank you. It's behind it? I don't see one. Hiding. Okay, he has 2 cases now. Do you want to waive his presence? Fingers.
Yes, I'll wait.
So do you want to give Ms. Hill the name of the victim on F-25-27603?
Is the public defender requesting it?
Yes, please.
Okay, it's Sherman Howerton.
So on both cases, are you okay waiving presence?
Yes, Your Honor, we can waive on both, and if I can get the victim's name on the other one too.
So what's the case number?
F-25-27623.
1 second.
So on F-25-2760, I'm sorry, 27603, there's probable cause for the charge. The bond is $2,500.
In the other case, the victim is Craig Gilbert.
There's multiple probable cause on the other case as well. $500 bond. Okay, next, Frank Botella, page 14.
Yes, Your Honor. He refused, he's been refusing since the 24th.
And they would decide now to have it 5 days? Oh, my finger.
They were waiting.
John, he's also known as John Doe. So you want me to appoint the public defender's office, waive his presence?
Yes, Your Honor.
They were waiting on you, Judge.
They're waiting for me. That's nice. Okay, for Mr. Botella, I will appoint the public defender's office, waive presence on F-25, 27501, risk probable cause for retail theft. That bond is $2,500.
Yeah, because. Yeah, because he came in as a
Corrections, your
John Doe.
microphone's on.
Yes, because he came in as a John Doe.
So do you want me to see John Doe?
No.
Okay. Then the next case, F-25, 27556, retail theft from December 13th. There's probable cause for the charge. $2,500 bond. And appointing public defender's office, waiving his presence.
Similine?
Good morning, Your Honor. We are hearing case 25 CR 1091, State of Ohio versus Joshua L. Smith. Present in court is a defendant who's accompanied by his attorney, Mr. Chad Mulkey. We were previously here on November 17th, 2025. At that time, the defendant withdrew his previously entered plea of not guilty and entered a plea of guilty to count 1, possession of marijuana, a felony of the 5th degree with an attached forfeiture specification. This matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation and report, as well as for a drug and alcohol evaluation. Those reports have been completed. The state has had an opportunity to review those reports, and the state is ready to proceed with sentencing, and the state would move to dismiss the remaining counts of the indictment at this time. Thank you. I apologize. And there are 29 days of jail time credit.
Thank you. Smokey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I do, Your Honor, and also his mother, Delisa Harris, is here and would like to address the court when appropriate, and I believe my client would also like to do so as well.
Well, we could hear from his mother at this time. Ma'am, wherever you are, you can stand right where it is that you're seated. State your full name and spell your last name for the court reporter, please, and then say whatever you'd like me to know.
Delisa Harris, Harris.
Can you spell the first name too?
Yep, I'm about to spell it Delleesa.
Thank you.
I'm here today to support Joshua, as we know. Truthfully, I've never been separated from any of my kids. There's been some things I've been going through health-wise. I may not look like it, but very unhealthy, which he comes into play to help do a lot of stuff with his siblings, and I grocery shopping, paying bills for me, running errands whenever I'm not able to be mobile because I have spinal issues that keeps me from walking a lot of times. I just want to say we don't have his father. His father passed away in 2021, so he's been kind of the guideline for his 4 brothers that he has at home. And without that, it's kind of putting me in a tight spot. I know he shouldn't be here, and I know he did some things that he shouldn't have done, but he's not a bad person. His character is not bad. He's a very well-rounded young man, and somebody I know who will go far, who's willing to actually work a job. And I'm just asking that he be able to come home because I need him. You may fault him for his wrongdoing, yes, but I do need him. We need him. And I do whatever it takes to keep him from coming back here. I don't raise him like that. I know they all make mistakes, but they got one mistake with me. And this the first and the last. That's all I'm going to say. Thank you.
Thank you. Smokey?
Thank you, Your Honor. Your Honor, he is 20 years old. He has his whole life ahead of him. He's not off to a very good start with the judicial system, but he'd like to, I think, put himself in a better light, steer the ship on a straight course, lead a law-abiding life. As you heard from his mother, he wants to help take care of his family. He was working at Amazon. He'd like to try to get that job back when available, or if not, find a suitable alternative. It looks like There is some marijuana use here. He may need some counseling for that. I think he understands that. Now, he started at a young age, and this is a marijuana-related charge. It hasn't progressed to any heavier drugs, such as meth or cocaine or anything like that. So I think this is a wake-up call to Josh to turn things around, and he'd like to give the court an opportunity to show that he can do that on probation. I know he does live in Cleveland with his mother and his siblings. He'd like to see in the future at some point, if possible, about transferring his probation to Cleveland. But he knows he needs to...
Why would I do that? You committed the crime in Lake County.
It's certainly up to the court. It would just make he doesn't have a valid license, so it might be a little bit more difficult for him to get here. So just wanted to bring that to the court for the court's consideration. Certainly, of course, defer to the court on where he has to be supervised, Your Honor. But I just wanted to mention that might make things a little bit easier to get to and from his probation appointments.
Make probation easier. That's why he wants to do it. But go ahead. Have I ever done that? I mean,
What, transfer supervision
to Cuyahoga County?
Well, not very often. Judge.
Not. Just stop right there.
Not.
Go ahead.
Thank you, Judge. He absolutely knows, and if it wasn't in any way clear to him before, to not use marijuana, not be associated with marijuana, not be around marijuana, or if there are any friends or family who are doing it, to not have it in his vehicle, be traveling with them, or be anywhere near it, Your Honor. And again, at 20, I think while he's still developing his life and coping skills, this is certainly a wake-up call. I'm sure he's going to bear the wrath of his mother regarding this, and the one chance that she gives him. So I'd ask the court to take all of that into consideration when imposing sentence today. We'd be asking the court for community control. He does have 29 days of credit. We'd ask for no additional jail to be imposed at this time, and I believe my client would like to address the court as well. Thank you, Your Honor.
Mr. Smith, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Can I stand up?
You can do whatever you like.
Cool beans. Well, I just want to say how you doing today.
Anything you want to say?
To be honest, sitting inside of the jail, for these last 29 days kind of, brought me to the conclusion that that's not something that I would want to do again. You know what I'm saying? And it also, initially brought me a little closer to God. And I've been doing a lot of praying lately, and I got a lot of faith in, the understanding of what's going on. And I feel like if you was to allow me to go home today, they for 100% would never ever see my face again. I set a goal in mind, and I came to the conclusion that I want to make $100,000 this year. And me being locked up inside of a cell, or just dealing with having the law on my back, wouldn't be able to help me make that $100,000.
How you plan on making $100,000?
Well, I'm a brick mason, sir.
Huh?
I'm a brick mason, sir.
Okay.
And I plan on starting a business with doing the bricklaying, and then I also have another business where I can go door to door and sell, insurance and home security and other things of the sort. So I just plan on getting my life together and working towards making that $100,000. I want to balance myself.
What do you do for Amazon?
I work inside of the fulfillment center. I just pack up people packages and send them out.
Is there anything else you'd like to say?
Well, I'm 20. I turned 21 in a couple months. You know what I'm saying? That opens a lot of opportunities for me. You know what I'm saying? A lot of things that I wasn't able to do beforehand, or wasn't able to be beforehand, I will be allowed to do this year. And I just ask that with that in mind, just allow me to go home so I can, get my life together and fix what I gotta fix.
Thank you.
No problem.
Smokey, anything else?
Not at all, Your Honor. Thank you.
Mr. Malone?
Thank you, Your Honor. Based on the facts and circumstances of the case, the state does recommend the court impose a sentence of community control sanctions with local jail time and treatment. Thank you.
Thank you. Court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation, considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today by Mr. Mulkey, the defendant, his mother, prosecutor, the recommendations. I received some correspondence as well. I also received a letter from the defendant previously as well as from his mother. I've read those and considered those.
Nice.
All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. So the factors in 29-29-12, factors indicating the conduct is more or less serious. The court does note other relevant factors indicating it's more serious as the sheer volume of the marijuana involved. We're talking almost 2 pounds of marijuana that was found, which is much more than we normally see in these types of cases. Nothing makes the conduct less serious. As for recidivism factors, there's a prior conviction on the defendant's record for the attempted carrying a concealed weapon out of the Stowe Municipal Court, which occurred just a couple months before this happened. The conviction itself, the offense was probably a year before that, but conviction was a couple months before. Defendant has a drug abuse problem that relates to the offense, and he denies it. He doesn't want any treatment, doesn't believe he needs any treatment. He's been smoking marijuana daily for at least the last almost 3 years.
Can I speak on that?
Sure.
The reason why I say that I feel as if I don't need treatment is because in all reality, before I even got caught up with any of this, I was in the process to stop smoking anyway. Smoking, I don't believe.
The process is. I'll let you finish first. Go ahead. I
don't believe that weed is a drug that I would need any type of treatment for. If I got enough mental stability to tell myself to stop smoking, and I could stop smoking. Just as well as I told you last time I was in court when you said I wasn't supposed to be smoking on bond, and I told you I would 100% stop smoking.
And you didn't. You kept using it.
No.
Your levels went up when you went back to the probation department the next time. Yes, they did. Don't tell me they didn't.
No.
Your levels went up from when you were here the last time. And I told you what's going to happen if you continued smoking. You went back there, and your levels were higher than they were the first time.
Okay, you say so, sir.
I say so.
You put a warrant out for my arrest 3 days after I told you that the weed was going to be inside of my business in general. You know what I'm saying? So I mean, I don't really understand that, but
I put a warrant out for you. You weren't arrested 3 days later.
But again, though, like I was
saying, a warrant doesn't do anything.
Can I finish talking, please?
No.
Excuse me?
Can I finish talking, please?
Relax.
No, you've had enough. I let you talk earlier. You had a chance to speak. It's my turn now. And you better stop that grinning.
I can't.
You come in here with a smile on your face, acting like we're buddy-buddy. That's not the case.
Okay, sir.
Boy, I don't think probation is going to work here. I was planning on giving him probation, but it doesn't look like that's going to work. Defendant's been smoking marijuana daily since he's been 18. Legally not even old enough to drink a beer, and you're smoking marijuana daily since you've been 18. Doesn't believe he has any problem with that. It's a condition of his bond that he not smoke marijuana, but he smoked it anyway when he was here the last time. says he didn't know he wasn't allowed to. There was a bond condition form he signed. So that's the same thing he said about the marijuana in the car. He didn't know the marijuana was in the car, yet there's 2 pounds of marijuana in the car. It's not like there's a little joint there. 2 pounds of marijuana in the car that he'd been driving. He just kept forgetting to take it out and didn't know it was there. And then when he was here last time, he was told, you can't smoke. And his levels went up. Now, apparently he thinks I'm just making that up. No genuine remorse. Doesn't believe he should have been charged with this. Doesn't believe he should have been pulled over. Are you going to keep talking? I've given you 2 chances to speak.
I'm talking to myself, sir.
Well, be quiet.
Okay, sir.
Factors indicate recidivism is less likely. There are no juvenile delinquency adjudications. In order for me to put you on probation, or we call community control sanctions, I need to make a finding that you're amenable to community control sanctions, and that's where I'm really struggling. That you're going to follow rules, do what you're supposed to do, follow the conditions that are set by the court. Why don't you have a driver's license?
Say that again?
Why don't you have a driver's license?
Because I got to pay some court fees in order to...
Oh, that's right. There's a warrant out for you, isn't there? You didn't show up. Warrant out of Shaker Municipal Court and Bedford Municipal Court. And show up for court on October 7th of this year.
Yeah,
for driving under suspension.
I didn't even know I had court.
You didn't know you had court?
No, I didn't, sir.
A lot of lack of knowledge on your part with a lot of things here. Didn't know there was marijuana, didn't know I couldn't smoke marijuana, didn't know I had court. Well, I will give you 1 chance, Mr. Smith. I'll find you're amenable to a community control sanction. If you test positive for marijuana, you're going to prison. So don't think of this as, oh, it's just some minor misdemeanor or whatever the case may be. You're going to prison if you smoke marijuana. You say you don't, you can stop it. You say you have the mental ability to do that. We'll find out. I hope you're right. Well, I'd love for you to prove me wrong. They'll put you on community control sanctions for a period of 2 years. Or I'm not going to send you out without any treatment. I'm going to order that you serve 89 days in jail. You have credit for 29 days you've served. I'm going to order that you enter and successfully complete the jail treatment program, get the treatment that they offer there, successfully complete that program, follow their aftercare recommendations. After that, conditions of your bond, you're not to use any drugs or alcohol. That includes no marijuana use. You're to submit random urine screens. They have to be negative. Positive screens a violation. You can't tamper with the urine sample, bring in fake urine, bring in someone else's urine, nothing like that. You're going to prison if you do that. To attend 2 AA meetings a week and have a sponsor. Obtain and maintain full-time employment. Immediately clear up these warrants when you get out. You can't be on probation having warrants out for you. And just so we're clear, so you can't say you don't know, there's 1 in Shaker Heights and 1 in Bedford Municipal Court. Shaker Heights Municipal Court, Bedford Municipal Court. Warrants in each of those communities. Once you get your driver's license back, pay your court costs and supervision fees. also want you to do a mental health evaluation, follow whatever recommendations are for any type of counseling or treatment that could help you with issues that you may have, that you talked about and that you went through when you were younger. Whatever recommendations are made in that regard. Derek, anything else I should be thinking about here?
No, Your Honor, thank you.
Mr. Smith, you understand the conditions of your probation?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, and I'm talking about from this day forward. So if there's issues with the DUS, that happened in the past, clear that up however you want to clear it up. It's not going to, if you wind up being found guilty or pleading guilty, it's not going to impact your probation. I'm talking about conduct from today forward. If anything like that should happen, a motion to terminate your community control sanctions will be filed. If it's found that you violated, it could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I can terminate your probation and send you to prison. And if I sent you to prison, it will be 12 months in prison, which will be consecutive to any other sentence you may be serving at that time or that you may be getting sentenced to at that time. You understand that?
Understood.
All right. Similar, anything else for the record?
Just the balance of the indictment and forfeiture, Your Honor.
Balance of the indictment is dismissed as agreed upon. I'm going to order the forfeiture of the contraband and instrumentalities, and I'll release any bond if their bond was posted. We're not forfeiting bond. Mr. Mulkey, anything else?
No, Your Honor. Thank you.
Robinson, case number 25CR001364. Defendant is present open court today with his counsel, William Watson. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on November 17th of 2025, where he pled guilty by way of information to count 1, telecommunications harassment, a felony of the 5th degree with a forfeiture specification, and count 2, menacing by stalking, a misdemeanor of the 1st degree. At that time, a pre-sentence report, psychological evaluation, and victim impact statement were ordered. The state's understanding that those were completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. I know this court's aware that Mr. Robinson does have a history with violations of protection orders. Prior ones were reduced from felonies to misdemeanors. This particular case, Your Honor, I mean, he did accept responsibility early on. He did take a plea by information. My client has just informed me. So previously, and I believe I put this in a prior motion I filed with the court, he was employed at Lincoln Electric, which my understanding is a very good company. However, he's just informed me, he brought to court today a letter, an offer letter for a dream job in sales. I'll let my client elaborate on that. I was prepared to ask this court for go a certain direction this morning. I know at the last minute I was informed that there may have been some violations with this same victim that's on this underlying case. I would just ask the court at the moment, their allegations. I know he's got a history of this, Your Honor. He did take responsibility in this case. He does not technically have a prior felony record besides this case now. I'm going to respectfully ask the court to take those factors into consideration. My client will like to say a few words. I know the court will allow him to speak, and I mean, he does looks like he has a good opportunity at a job coming up. I'm going to ask the court to take all those factors into consideration. Thank you, Your Honor.
I stand up.
Mr. Robinson, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say?
Yes, sir. I know that this doesn't look good. I made a mistake. Mistakes. I love hard, and I think there are some definite psychological issues, but I'm working on myself right now. I just got hired at Home Genius Exteriors to do traveling sales. Since I did my pre-sentence report, I've got my driver's license and a job. So a lot of my issues is with free time, and I'm filling those gaps. You know, I have a 5-year-old son and a 13-year-old daughter. I got my dad over there. I have a great support system. My grandpa's 92 years old. My dad's over there. You know, they support me very much. And I just want an opportunity to, I want to prove the court wrong, and I want to prove all my past with this wrong. I know I can do it, and I want the opportunity to. I just want to start my life over and move forward.
All right, thank you.
Thank you, sir.
Mr. Watson, anything else?
No, Your Honor.
Cuts for the state of Ohio.
Thank you, Your Honor. Your Honor, this case encompasses an extended period of time from May through September of 2025. That's for the menacing by stalking, and the telecommunications harassment is August and part of September until the defendant was arrested. In that time frame, defendant was calling Ms. Knapp an amazing amount of times, as well as texting, showing up at her work, at her home, delivering things. We often hear about telecommunications harassment, dozens of calls a day. This is hundreds to over 1,000 for some days. There were 3 different texting formats, a regular texting of your phone, as well as through Text Now and WhatsApp. There was one of them in less than a 24-hour period, 365 calls through that. In a 4 or 5 day period, 106 text messages through regular text on the phone. Others had 95 in a week-long period. That's just the texting. The phone calls, there was one day that had 1,200 calls. Other days that had over 1,000 or 700 or 900, to the point that Ms. Knapp's voicemail would be full because she didn't answer the calls. She was concerned to answer any phone numbers because she blocked over 40 numbers, because once she would block one number, he would get a different number or use somebody else's number. She felt like she couldn't relax if he would come to her house. There were multiple times he was recorded on her Blink camera coming to her house, knocking on the door. She was working on getting a job, so she was missing calls for jobs because she was afraid to answer it, not knowing who it was, and they couldn't leave a voicemail for her. She made multiple reports to Lake County Sheriff's Office before she ever got the protection order. Most of the time they would call and tell him to stop. She did get a protection order right before she went to the police in this case. While she was talking with the deputy, the defendant called multiple times. She answered for the deputy spoke, told him to stop calling. He indicated he wasn't going to stop calling, and then continued to call while they were still meeting. He's had deliveries to her home and to her work.
Let me stop you. You're denying this?
No.
You're denying a police officer told you to stop, and you said that, and that you weren't gonna, and you continue calling even after
No,
that?
about the delivery, sir. I did deliver pizza to her sons. I did
No,
deliver
I'm not
flowers
talking
to
about that.
her.
I'm talking about the police officer telling you, stop calling, and you telling the police officer, I'm going to keep calling her, and you continue calling her.
No, I didn't.
All right, because you're sitting there shaking your head. But,
No, I'm...
Go ahead, Ms. Cutts.
Sorry.
Thank you, Your Honor. So Ms. Knapp has not been able to relax for a very extended period of time. Obviously, the relationship with the victim facilitated the offense. They've known each other at least 2.5 years. They do have different versions of their relationship. She does not indicate that they had a long-term romantic relationship and that they were friends more than anything else. The phone records have indicated these number of phone calls and text messages, all of that information. He does have a criminal history that includes 1 juvenile adjudication in 2000 for disorderly conduct, but his adult history also began in 2000. Loud music, 2003, conviction for disorderly conduct, 2005, convictions for drug abuse, as well as a separate case of possessing drug paraphernalia. 2007, he has a drug abuse conviction, as well as an OVI. 2011, he had a possession of drugs that was reduced from a felony to a misdemeanor. He had a probation violation in that case. In 2013, he had another possession of drugs, which was reduced from a felony to a misdemeanor. He had a probation violation in that case. 2013, he also had convictions for assault, a theft conviction that was reduced from a felony, and a contempt of court. In 2016, he had misuse of credit cards that was reduced from a felony, as well as contempt of court. He also had receiving stolen property, some convictions for permit fees or work without permits, contempt of court. 2020, a conviction for failure to control drainage. There may be a warrant out in that case. There's also an assault that was reduced from a domestic violence, where he had a probation violation and a telecommunications harassment. 2021, he has a conviction for violating a protection order and contempt of court. 2023, convictions for assault, menacing, criminal damaging, and resisting arrest. He had a probation violation in that case. In 2023, again, he had a drug abuse, 2 counts, conviction with a probation violation, and in 2024, conviction for escape, a probation violation. He currently has a warrant out for Parma Municipal Court for a 2019 case for failing to appear. When he committed these offenses, he was on probation in Parma for that case. There were some issues when he was in the jail. Appears in September there was threats violation. As I say, there have been some inconsistencies in that the defendant has given versus what the victim has indicated, as well as even in his report. At one point, he said he sees his kids whenever he wants, to who did the psychological, but he told probation that he hadn't seen his son in an extended period of time. So he has not responded favorably to previous sanctions, the probation violations, convictions, being on probation, and the state just learned this morning of at least a violation of his probation. I believe he has been arrested on a warrant for new charges. Obviously not a conviction at this stage, but the information that was received by the victim advocate directly from the victim, not just what law enforcement was indicating, was that the defendant has been calling her for weeks, showed up at her new work about 3 weeks ago, has been leaving things on her car, and that the biggest issue yesterday, she was leaving her house. When she got to her car, the defendant began screaming at her from a vehicle he was in. When she got into his car, into her own car, the defendant came up to her car and was banging on her windows. Her son came out, who was also under the protection order. The defendant spit on the victim and then ran to his car, and whomever was driving the car, his friend Mark, drove off. So it's my understanding they got a warrant and he was arrested on that day. I've not seen any police reports or anything of that nature, but Ms. Knapp did inform our victim advocate today. She would have been here today, except she is ill, that had happened yesterday. So at a minimum, it's a violation of his probation based on the information she's providing us.
Probation.
Sorry, a violation of his bond. I misspoke, you are correct. At a minimum, he was on probation when he committed this offense. I do believe, the state does believe prison is consistent. When Ms. Knapp came for the information plea, she had indicated since he had been arrested, he had been leaving her alone. So we were hopeful and optimistic that that would continue. The fact that he has not done so seems to indicate that he is not going to stop, especially it being the day before coming into court for his felony sentencing. So based on that, we do not believe he is amenable to community control, and we would ask for prison in this case. There is the forfeiture of the cell phone, and that would be the state's recommendation at this time. He has 0 days credit. Any time he served was for another sentence.
Thank you. This court has reviewed the pre-sentence report and investigation, psychological evaluation, consider the facts and circumstances of the offenses involved, the nature of the offenses. I've considered what's been said here in court today by his lawyer, Mr. Watson, the defendant himself, the prosecutor. All this is considered by the purposes and principles of felony sentencing set forth in 29-2911 of the revised code. So the factors in 29-2912, factors indicating the conduct is more or less serious. The court knows the defendant's relationship with the victim facilitated the offense, and the victim has suffered serious psychological harm as a result of the defendant's conduct. Other factors indicating it's more serious are the relevant factors. I've been doing this for a long, long time. I've never had a case like this with this much disregard for orders and for the sheer volume of phone calls that were made to this. I don't know how that's even physically possible to make 1,000 calls a day, 600 calls a day, text messages. I assume you sleep a little bit, so that even narrows it down somewhat. I don't know how you do that. The sheer volume of calls and contact that you made formed the basis for this. It's the worst I've ever seen. Nothing makes it less serious. As for factors indicating recidivism is more likely, the defendant committed this offense while he was on probation. There's a history of criminal convictions, and part of the problem is that he's had at least 5 cases that have been reduced from felonies to misdemeanors. And I think the defendant's gotten used to that. Not facing consequences for his conduct. He's getting breaks and just expects that. He's clearly not responded favorably to previously imposed sanctions. He's been on probation before. He's violated his probation. Again, he's gotten multiple offenses and reductions. And in terms of not following previously imposed orders, that's the whole nature of the cases here. Prior violation of protection orders, harassment charges. Just in the last 3 charges, violating a protection order, telecommunications harassment, menacing, assault, resisting arrest. It's just a pattern here that the defendant does over and over and over. You made a comment earlier about this being a mistake, and I said mistakes. This isn't a mistake or mistakes. Mistakes are somewhere you don't intend to do it, and it's some accident. These are deliberate actions that you do over and over and over, 1,000 times a day. Those aren't mistakes. You're deliberately disregarding orders. Even the police said stop doing it. You told them, well, I'm not going to stop. I'm going to do it. I don't know why. I can't figure this out. There's no way this court could ever make a finding that you're amenable to community control sanctions, which means that you're going to follow court orders, you're going to follow the rules of probation. You've demonstrated that you're not going to do it. You've vocally said you're not going to do it. There's no way you'll ever comply with conditions of probation. You've told us you're not. No factors indicate recidivism is less likely. There's no genuine remorse also in regards to recidivism factors. Under 2913B1, court finds, again, the defendant was on probation at the time he committed this offense. Prison is consistent with the purposes and principles of sentencing. As I earlier indicated, the defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 1, the defendant served a term in prison of 11 months. On count 2, he served a term of 180 days. It's in the misdemeanor. It must be concurrent. There's no credit because all the time he spent was serving another sentence. Need to advise you upon your release, you may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 5.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs, and I'll order the forfeiture of the contraband and instrumentalities. Cuts, anything else for the record?
No, thank you, Your Honor.
Bond will be released. Mr. Watts, anything else?
Nothing further, Your Honor.
Recording in progress.
I don't want to interrupt you.
So, did we catch any of that?
It was all games on it. Yeah, you're good. Don't worry. You are.
So you stopped me for what reason?
I should have just pushed it button.
And that told me.
Yeah.
Okay. Glad we're getting along. I'm also glad 2025 is ending. Court does call the case of the people of the state of Michigan versus Derek Smith.
Ashley Feltus for the people. Morning, Anna. Uwe Dawes appearing on behalf of Derek Smith, who is joining us via Zoom. Derek, would you unmute and state your name for the court, please?
You got him? Okay.
Hi, my name is Derek.
All right, got it. All right, what are we doing?
There's a PCC adjournment sheet in the file. I'm looking to adjourn the PCC once more for discovery and investigation due to our recent action.
Probable cause conference without objection will be adjourned to January 15th. 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, sir. Court does call the cases of the people versus Wesley Brand.
Alexander on behalf of the people.
You have to push it. Hey, I don't have that key.
And Alex Warren Green on behalf of Mr. Brand. Mr. Brand, could you please state your name?
Wesley Brand.
State your name again, please, sir.
Wesley Brand.
Okay, thank you. All right, what are we doing?
Your Honor, I'm asking to adjourn both of these matters so that we can complete discovery in each case.
So, the discovery issue.
Your Honor, in the 1713, there is outstanding media discovery. I spoke with the people. I believe they received it and are sending that over if they haven't already. In the 2209 case, we need paper and media discovery, but I did speak with the people on both fronts.
And Your Honor, both of those should be coming over to defense, and there is one video that I requested that wasn't immediately discovered that I'm waiting on as well from YPD.
All right.
And I don't believe their records office will be out until next week.
You can just stop there. Are these the only cases holding him? Do you know?
He also has another case out of 1481 for assault on a corrections.
That's correct, Your Honor, and nothing out of county.
Probable cause conference, January 8th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the people versus Stephen Black.
And then on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Mr. Black. And Mr. Black, state your name when you get here.
Stephen Black.
And
take your hands out of your pockets.
And Your Honor, I hope the court has signed my substitution of counsel.
Nope.
I asked the court.
Yes, I did.
And accordingly, requesting to adjourn the PCC as I've just entered the matter. I know the court loves when I request dates, but the date of the 15th would work well if that's possible.
Why did he do that?
Because I know you love.
No, why did you do that?
I know you love.
I'm 3 cases in. January 15th, 2026, 9 a.m. Bond continue.
Your Honor, regarding bond, well, I'm sorry, you talked to, I couldn't get it in. What should be relatively easy? The current exclusion zone of the tether includes my office. And so if the court, will amend that to allow my office to be permitted, I'll have my client report to community corrections and they'll figure out it's literally on the border of the exclusion zone.
Your office is.
Yeah.
Any objection from the people?
And the other one, I already told.
Another?
Yep, but I know what the court's going to say, but anyway, there are 2 family court orders regarding contact with my client's minor children and his spouse. One is a PPO order and one is a family law order, both before Judge Slay. And they are actually in conflict with one another. So
Judge Slay's orders?
The people with the one was entered ex parte. They're just minorly.
So Judge Slay entered orders that are in conflict.
She's not.
Let me call her.
They're great.
You said that.
She's not aware of this, but I'm sure. What I'm asking if the court would permit contact as Judge Slay orders with the minor children and my client's estranged spouse for child visitation purposes only.
Is there a response from the people?
I think once we review the order, we can submit a step report after we have everything kind of all.
Right, and typically, unless the people perceive some other danger that the family court may not be aware of, I will follow the family court's order. But if the people do object, then I would certainly make a more restrictive order. Okay, so I will allow the zone to be amended so that your office is outside of it, or they can keep the zone, but a violation would not occur if he's
either way.
And then you guys can get to me the order. Council approach briefly, just.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Apologies for a moment or two of silence there. I had to step out of the studio because we had cats acting like fools, so that had to be dealt with. Barbara, thank you for gifting me a membership to my own channel. Very much appreciate it. Yes, that is the third time by my count I have been gifted a membership to my own channel, so appreciate that. Looks like Judge is back, so let's continue with him.
You think that needs a new order? Probably his zone. Mr. Simon's getting the chest on the outside of the zone.
I think I can just put like no violation to address, and that's good.
I think you can do it that way, but the other thing is, I'm not sure where the prohibited premises is vis-a-vis that zone.
It's on Cook Street, KOCH, which is a couple of blocks from my office.
That's the excluded area.
Yes.
Oh.
So the perimeter literally touches my.
Got it.
Yeah.
Got it. So, okay, they'll have to figure something out. They know where their prohibited zone is. We'll work it out.
All right, thank you.
Thank you. Court calls the case, People versus Stephanie Cruz Mena.
Good morning, Your Honor. Jeremy Glick appearing on behalf of Stephanie Cruz Mena via Zoom. And Stephanie, when you reach the podium, could you please state your name?
Oh, there's Mr. Glick. Okay.
Oh, Stephanie Cruz.
All right. She stated it. Go ahead, Counsel.
Thank you, Your Honor. We have received the discovery Friday from the people. There's quite a bit to review as well as some investigation on our end. We would ask for a short adjournment and to address bond.
All right. Without objection, probable cause January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Clark. Court calls the case of the People versus Edward Dagnas.
Comes over what is the prosecuting attorney for the people.
And Your Honor, Joe Simon on behalf of Mr. Dagnas. State your name, please.
Edward Dagnas. Thank you.
All right, we are trying to work out a plea agreement in this matter. The issue is determining what the restitution number is going to be. My victim advocate has been in contact with the victim in this case. There's been issues around getting cost of potential medical bills and insurance repayments. So if we could get an adjournment on this matter, Your Honor, I will follow up immediately, try and get this to Mr. get it to council as soon as possible.
And Your Honor, I'll just add one more thing. There's also a piece of discovery that I want to keep on the radar that we need to.
And I have reached out to POIC about that. If we can get it, we will have.
All right. January 15th, 2026, 9 a.m. on continued. I don't know.
Thank you, Your Honor. Ed, if you can get one.
I don't have a green sheet. for Mr. Simpson.
Oh, don't.
I don't. have a green sheet. Apparently,
No.
he thinks he doesn't have to.
No.
That's.
No.
You'll address that.
Mr. Overwater was going to totally eat that bullet, Your Honor, but because that wasn't on me.
That is true.
I don't believe either one of you.
Happy New Year.
I don't believe either one of you. You're just covering. Court calls case of People versus Amari Harris.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Is that it for you, Mr. Simon?
Happy New Year, Your Honor.
And to you. I did not want to give you holiday greetings like the last time.
Thank you. A little hurtful.
Yes.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Amari Harris.
Your name, sir? Amari Harris. Thank you. All right, what are we doing?
Your Honor, we're requesting an exam. I know the last time we were in court, there were another lawyer had showed up, but we're asking for an exam.
All right.
And a co-defendant.
Does he have a co-defendant?
He does, Ms. Cruz Mena, that was just adjourned to January 8th.
Okay. But he's requesting an exam.
Your Honor, Jeremy Glick on behalf of Ms. Cruz Mena. I'm still in the courtroom. If it's relevant to the court, we'd be fine as well doing an exam if we could push that until the 15th to give us 2 weeks for some additional discovery and investigation.
So, well, the exam would be sometime that week. I don't know. I would normally be setting this for what, the 6th?
Yes.
But the 13th. So I can set exams in both of those matters for the 13th, if that will work with counsel.
That would work for us, Your Honor.
Yes,
It
yes,
would?
Judge, that would work. I'm already in court and an exam that day in front of you.
Okay, so let me take care of this one, and if you can hang on a second, Mr. Glick, and the discovery at least is complete, relatively speaking, to proceed to an exam. Would the people have their witnesses available the 13th?
I'm sorry, Your Honor, I apologize.
Would the people have their witnesses available January 13th?
I don't see any reason why we would not.
All right. Is that mine? Huh? Oh, we don't have a.
Correct, yeah.
Just because it's a capital. Can we try to find out what they're doing? Because I don't. Maybe we'll know by Monday, but maybe, who knows? All right. So I'll set preliminary examination on both of these cases for January 13th, 2026, 9 a.m. That's before me. That's in person, but we'll continue. And Mr. Glick, on your case, would you like your client brought out if I were setting that date, or?
No, Your Honor, I can connect with her in the jail and let her know.
All right, so waiving the appearance, I will also set preliminary examination in that matter for that same date.
Thank you very much.
Thank you, folks.
Thank you.
Thank you, Judge.
Mr. McDaniel, I'm happy for you to call the cases as you wish.
Thank you. Sean Blevins.
It's a DOC release, prison release. Mr. Blevins, good morning.
Good morning. How are you doing, Ms. Garcia?
I'm well, thank you, Mr. Blevins. Mr. Blevins, did you did you understand and hear the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Mr. Blevins, you are currently in custody for allegedly violating the terms of your release from the State Department of Corrections. Most importantly, the alleged contact that you had with someone under the age of 18. Mr. Blevins, I am going to hold you without bond to see what DOC is going to do as far as that release, which means you can't be released from custody pending that resolution. Do you have any questions for me?
Yes, ma'am.
Yes, sir.
So this ain't got nothing to do with the you or the regular state or anything?
No, sir. Unfortunately, this is just a Department of Corrections issue because it's my understanding that you were in prison and you got released on some sort of supervised release, right? So
Yes,
that
ma'am.
it's not the state attorney's office in the 14th Circuit or this court because you're not on probation for us.
Yes, ma'am. Do you know how long it might typically take for them to come see me?
2 weeks, sir.
2 weeks?
Yeah.
Is that what you said, John?
Yes, Your Honor, about 2 weeks.
Okay, 2 weeks. Okay, yep, about that time.
Right.
John's the one, John and everyone who's here normally is who knows that more than me because I don't deal with this as often.
Yes, ma'am.
But with that being
Okay.
said, they can open up to March. They normally see it within 2 weeks. It could be longer, but they don't.
Is March his EOS date?
Yeah, that March is the EOS date. They don't have to have a reason. They normally do come within about 2 weeks.
But they normally do come. All right. All right. So that's what we got, Mr. Blevins.
Yes, ma'am. Thank you.
Good luck to you, sir.
Jan Caps.
Ms. Capps, good morning.
Go ahead and. Good morning.
If you need a second, Mr. McDaniel, you may talk to her and then just let me know when you're ready.
Thank you. We're ready to go.
All right. Ms. Capps, tell me your full name for the record, please.
Jan Renee Capps.
Ms. Capps, did you understand the video or the rights that were explained to you on the first appearance video?
Yes, ma'am.
Ms. Capps, you have been charged with 1 count of driving while license suspended or revoked. Ms. Capps, this could be a second-degree misdemeanor punishable by up to 60 days in jail, or as high as a third-degree felony punishable by up to 5 years in prison. Ms. Capps, I do see numerous prior DWLSRs on your record, and so I think this might be as high as a third-degree felony. Ms. Capps, I've reviewed the probable cause narrative. I do find that there is sufficient probable cause for that charge. Ms. Capps, are you on probation anywhere at this time?
No, ma'am.
Ms.
I
Capps,
haven't
do you
been
have
in any
any
trouble in 5 years.
Sure. Ms. Capps, do you have any pending criminal charges? I know that you just said you haven't been in trouble in 5 years. I just need to know
No,
the
ma'am.
answer to that question. All right,
No,
give me
ma'am.
1 sec.
And Your Honor.
Yes, sir.
I did just want to state, me and Mr. McDaniel were in discussions about a potential plea offer
What you
this
got?
morning.
Tell me what you got.
My initial offer was going to be the first degree misdemeanor level of DWLSR, but
Okay.
I did not have a chance to look at her history. And based on what you're telling me right now,
So
this
here's
could-
what I got. I have in 21, I have a DWLSR. What was going to be your offer?
it was going to be 1 year probation, but if
Oh, yeah.
if
Okay.
it's potentially could be felony, I might need time to review this before I can go forward with any offer. So I think for purposes
I don't
today, it
think
may be
it's-
best just
John,
I don't
what you
think
know?
it's a good fit. Because I didn't see, the one in 21 got dismissed, and she had some others, they probably prior. Georgia's are not going to count against her, because if they were, I'm just guessing, maybe Georgia, Alabama, because those don't require knowledge, so those are not even going to be enhanceable. I didn't see anything in Florida. Now, I don't see Georgia or any other state.
Here's what I got, John. I've got dropped abandoned in 21, and I think it's the same. Dawn, you don't pull driving histories anymore?
I just wasn't aware of that.
Oh, it's okay. I just didn't know if you had it, is why I'm asking.
I can get it really quick.
How quick?
We're going to come back to her. and
Yeah,
get
let's
driving.
pass her. Why don't we pass her, because that might be beneficial to her, and then
Of course, if she has-
Dawn can get it.
Yeah.
All right. Who you want to
So,
call next?
Cleveland Dixon, case number 25609 MM Cleveland.
Fair enough. Mr. Dixon, good morning.
How you doing, man?
I'm all right. Thank you, sir. Mr. Dixon, tell me your full name for the record.
Cleveland Dixon.
Mr. Dixon, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
Excellent. Mr. Dixon, you have been charged with one count of trespassing. It is a first-degree misdemeanor, punishable by up to a year in jail and/or $1,000 fine. I have reviewed the probable cause narrative, and I do find that there is sufficient probable cause for that charge. State defense, how do you wish to proceed?
I believe
No, we
Ms.
have-
McDaniel may have something. Yes.
We have a resolution to the case, Your Honor.
All right.
Your Honor, Mr. Dixon, I spoke with him about this. He's going to plead no contest to the charges listed. He'll be sentenced to 9 months in the county jail. He'll have 7 days jail credit. There'll be a $370 fine. This will run concurrent with any other sentences he may have. And he also be adjudicated guilty of this crime.
Is this the agreement with the state?
It is, Your Honor.
Does the defense stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
All right, Mr. Dixon, please raise your right hand. Sir, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Dixon, you can put your hand down. Mr. Dixon, did you hear what Mr. McDaniel announced about resolving your case?
Yes, ma'am.
Is this how you choose to proceed?
Yes, ma'am.
Has anyone promised you anything other than what he said to get you to do this?
No, ma'am.
Is anyone threatening you?
No, ma'am.
Mr. Dixon, do you understand that by entering into a plea today, you are giving up your right to go to a trial where the state has to prove that you did what they say you did?
Yes, ma'am.
Do you understand you're giving up the right to present any defenses you may have to the alleged conduct?
Yes, ma'am.
And do you understand that you are giving up your right to appeal anything except an illegal sentence by this court?
Yes, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
All right, Mr. Dixon, I find that your plea is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or from the defense. Mr. Dixon, in this case, I accept your plea of no contest to one first-degree misdemeanor count of trespass. I adjudicate you to be guilty of the underlying offense, and I sentence you to serve 9 months in the Jackson County Jail with credit for 7 days that you have already served towards that sentence. This sentence shall be served concurrent with any other sentences that you may currently be serving. I order you to pay court costs, fines, and fees in the amount of $370. Those will be reduced to a civil judgment, but Mr. Dixon, much like you heard me tell Ms. Scott, if you wish to work off those fines, and I recommend that you do, you may do so while you are in the jail. If you don't work them off, then those will be just a civil judgment against you. Mr. Dixon, is there any objection to being considered for trustee status?
No objection.
Mr. Dixon, if you are eligible, you may also serve as a trustee. That is a program you must qualify for. And if there's a place for you where you can do additional work, then that may get you a little bit more gain time on your sentence. Mr. Dixon, do you have any questions for me about the sentence that I have just imposed?
No, ma'am.
And no? Okay. Anything further from the state or the defense?
No, Your Honor.
No, Your Honor.
Did I already tell him his appeal rights? Mr.
did not.
Dixon, I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Mr. Dixon, I wish you well, okay?
Yes, ma'am.
All right, thank you.
I think this is Lewis Phillips.
Lewis Phillips. Case
Good
number
morning, Mr.
25.
Phillips.
Good morning, Judge.
Mr. Phillips, tell me your full name for the record.
Louis Phillips.
Excellent. Mr. Phillips, I know this is not your first time coming up to first appearance, but did you have an opportunity to watch the video regarding your first appearance rights?
Yes, ma'am.
And did you understand those rights explained to you?
I understood my right.
Excellent. Mr. McDaniel, tell me, what are we here for this morning?
Your Honor, we have a resolution to this case, 25610MM. I've spoken to Mr. Phillips. He's going to want to enter a plea of no contest to the charge, which is essentially resisting without violence. Understanding he'll be sentenced to 30 days in the county jail. He'll have 4 days jail credit. There'll be a $370 fine. He'll be adjudicated guilty, and that'll resolve this case this morning.
Tell me 430, is that what you said?
375.
Yeah, 370.
I have no idea where I got 430. Okay, 375. And Dawn, what was the charge is interfering with first responder on duty. Is that what you understand the charge to be as well, Mr. McDaniel?
Yes, Your Honor.
Excellent. Is that a first degree misdemeanor? Second degree misdemeanor?
This one's
Hybrid?
first
Okay, excellent.
And
Thank
that is- And that is the agreement with the state, Your Honor.
Excellent. Mr. McDaniel, do you stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
Mr. Phillips, please raise your right hand, sir. So do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, Mr. Phillips. Mr. Phillips, you can put your hand down. Tell me your full name for the record again, just for the record.
Louis Phillips.
Mr. Phillips, did you hear Mr. McDaniel announce the resolution in this case?
Yes, ma'am.
Is this how you choose to resolve your case?
Yes, ma'am.
Has anyone promised you anything other than what he just said to get you to enter into this plea?
No, ma'am.
Is anyone threatening you?
No one.
Mr. Phillips, do you understand that by choosing to enter a plea today, you are giving up your right to go to a trial where the state has to prove that you did what they say you did?
Yes, ma'am.
Do you also understand that you are giving up your right to present any defenses that you may have to the charge?
Yes, ma'am.
Finally, do you also understand that you are giving up your right to appeal anything except an illegal sentence by this court?
Yes, ma'am.
Are you doing this of your own free will?
Of my own free will, ma'am.
All right. Mr. Phillips, I find that your plea is knowingly and voluntarily entered into after the advice of counsel, and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or from the defense. Mr. Phillips, in Jackson County case number 25MM610, I accept your plea of no contest. 1, first degree misdemeanor charge of interfering with first responder on duty. I will adjudicate you to be guilty of the offense and sentence you to serve 30 days in the Jackson County Jail with credit for 4 days that you have already served towards that sentence. I will also impose court costs, fines, and fees in the amount of, guys, is it 370 or 375?
370.
370. Okay. In the amount of $370, sir. You may work those fines and court costs off while you are in jail. However, if you don't do that, then those will be reduced to a civil judgment if not worked off while in jail. Dawn, will you add that little part about?
Yeah.
Okay, perfect. That's all right. I know you may not have been done. Mr. Phillips, I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Mr. Mitchell, do you have any objection to Mr. Phillips being considered for the trustee program?
No objection, Your Honor.
Mr. Phillips, the court has no objection to you being considered for the trustee program. However, that is something you have to qualify for and apply for at the jail. But if you get into the trustee, you may be eligible for additional gain time off of your 30-day sentence, okay?
Yes, ma'am.
Do you have any questions for me, sir?
No, ma'am.
Is there anything further from either the state or the defense?
No, Your Honor.
No, Your Honor.
All right, Mr. Phillips, I wish you well. Guys, stand by. We're getting the driver's license record in just a sec.
Yes, Your Honor.
Almost literally a sec.
Thank you, Dottie. Appreciate you. Okay, Dawn, I can't, will you help me? Tell me what it says. I need you to decipher. You read these much more than I did. I'll repeat whatever you say so that they can hear it. Do you read these, Chuck?
Every now and then, but even I.
Yeah, Dawn's the master.
I can see sometimes.
She has, looks like mainly her suspensions are FR cancellations.
All financial suspensions, so won't qualify for a, right? Are you seeing anything other than a financial?
And I know it was for financial reasons. they got
John, you
suspended.
want us to take pictures real quick? You know what would make
No,
me
no.
feel much better, John, though? Is if I take pictures of this and send it to you.
Well, I guess my only question, I knew it was financial. I can look that up myself. My only question was, has she ever had a prior DWLSR on the record?
She had one in Jackson County, a driving while license suspended, in 2010.
2010 in Jackson County, what happened then? Was it an,
That's fine.
It was a unknowingly driving while license.
it was an unknowingly?
So it'd be a second degree.
There were
misdemeanor.
points assigned, she said.
Yeah, 6 months probation.
So 2 second-degree misdemeanors max, right?
It'd be a second degree misdemeanor then, Your Honor. 6 months probation.
John, you want us to send you this picture of the driving
No,
record?
no, I don't know. what
You
she
feel
looked
good
at.
about
I-
it?
Absolutely. Yes, Your Honor.
She had a prior state.
She had a prior state license out of Colorado. I'm just repeating in case you can't hear, Dawn.
Yes, Your Honor.
I don't know what.
Jake, I'm good with the second-degree misdemeanor if you're good with it and going ahead and getting it resolved unless you tell me otherwise.
Based on what I've heard today, I'm fine with it being a second degree misdemeanor. And in that case, I think the offer would just be amended to 6 months probation.
Mr. McDaniel, you want a second to speak to her?
No, Your Honor, she's going to enter plea.
All right, fair enough. So tell me, well, hold on. So I've already asked Ms. Capps and told her what she was charged with. Ms. Capps, listen carefully to Mr. McDaniel and tell me if this is what you want to do, okay? Listen carefully.
Your Honor, I spoke with Ms. Cap. She's going to plea of no contest to driving my license suspended, revoked. The understanding should be placed on probation for 6 months. That $400 fine. If she gets her driver's license reinstated within 60 days, that fine would be $300. She's not to drive a vehicle without a valid license. And this will resolve this case today. She has signed her plea waiver form with the right to pre-trial and call witnesses.
All right. Ms. Capps, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Tell me again your full name for the record.
Jan Renee Capps.
Ms. Capps, did you hear the announcement that your attorney just made about resolving your driving while license suspended or revoked charge?
Yes, ma'am.
Is this how you choose to proceed?
Yes, ma'am.
Has anyone promised you anything other than what he just said to get you to enter
No,
into
ma'am.
this plea? Is anyone
ma'am.
threatening you?
No, ma'am.
Ms. Capps, do you understand that by entering into a plea today, you are giving up your right to go to a trial where the state has to prove the allegations against you?
Yes, ma'am.
Do you also understand that you are giving up your right to present any defenses that you may have to the allegations in the complaint?
Yes, ma'am.
Finally, do you understand that you are giving up your right to appeal anything except an illegal sentence?
Yes, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
All right. Ms. Capps, I find that your plea is knowingly and voluntarily entered into after the advice of counsel. Mr. McDaniel, do you stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
And I also find that there's a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Ms. Capps, in this case, I accept your plea of no contest to 1 second-degree misdemeanor offense of DWLSR knowingly. I will withhold adjudication of guilt, and I will sentence you to serve 6 months county probation. I will order you to pay court costs, fines, and fees in the amount of $400. However, if you obtain a valid driver's license within 60 days of being placed on probation and show proof of the same, your fine will be lowered to $300. I order you not to operate a motor vehicle without a valid driver's license. Ms. Capps, we see so many people here for no valid DLs, and people don't think these are serious charges, but you could absolutely end up in jail for no valid DL, and I need you to understand that. If you get a no valid DL, or excuse me, a DWLSR again, it could be 60 days here plus a year for the new one, okay? Do Yes, not ma'am. drive without a license. Yes, ma'am. I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Ms. Capps, what will happen now is you will be released from the jail and brought to the Jackson County Courthouse. At that time, our county probation officer will instruct you as to the terms of your county probation. And there are general conditions of probation that I order you to comply with, okay? Anything else I have to tell you right now? No? All right, anything else, State Defense?
No, Your Honor.
No, Your Honor.
All right, well then, Ms. Capps, I wish you well. And I think that takes care of first appearances, right, guys?
Yes, ma'am. We got you.
All right, thank you.